Good afternoon, everyone. Muy buenas tardes. Thank you for this beautiful panel entitled Envisioning the Future Towards Sensible Human Rights-Based Policies for Ayahuasca Practices. We have some updates with the participants, but I will explain right now. It's we have confirmation from Joao Goulao and Mr. Ahmed Saheed. Joao Goulao has been the National Drug Coordinator of Portugal since 2005, and he has 25 years of experience in drugs and health-related issues, and also he is a member of Scientific Committee of European Monitoring Center for Drugs and Drugs Addiction. Unfortunately, Joao had to cancel his participation in the conference because of series of personal issues, but we wanted to acknowledge his presence also here in this hall. Also, I would like to mention that Mr. Ahmed Saheed, the Special Rapporteur on Freedom of Religion or Belief, also had to not cancel but change his way of participating in this panel, and he will participate with a video. I would like to, for those who doesn't know Ahmed, he is the Special Rapporteur on Freedom of Religion or Belief, and he's this figure is he's an independent expert appointed by the UN Human Rights Council, and the mandate consists in identifying existing and emerging obstacles to the enjoyment of the right of religion of the right to freedom of religion or belief, and he also is in charge of presenting recommendations on ways and means to overcome these obstacles. So Ahmed will be participating by video. Just this parenthesis on the starting of the panel to acknowledge also the participation of these two big figures. But we also have three big figures with us this afternoon. Welcome, Charlotte. Welcome, Jeffrey. Welcome, Ben. I have the pleasure to be discussing today about how we can approach the future of ayahuasca policy, the future of human rights related issues in relation to ayahuasca. And the aim of this panel is we would like to have a conversation between the three of them and the four of us on what are like the recent developments in policy, public policy and human rights related, ayahuasca related issues, also potential scenarios for the coming years. So where we are in this moment and how can we look at the future, and how through making this exercise of looking at the future we can probably make this future we envision to become reality. So let me starting by introducing first of all Jeffrey Bronfman. Welcome, Jeffrey. Jeffrey was the lead plaintiff and legal strategist of the União do Vegetal, the UDV, a successful legal action to secure its rights to the religion use of its sacraments in the United States. It was a very important case that went all the way to the United States Supreme Court. You have probably heard about this case. And since this case has very important effects on how the law is interpreted today at the global level. Today, in addition to his continuing work on behalf of the UDV International, he is a member of the steering committee of ICEER's Ayahuasca Defense Fund. Then I will introduce Charlotte Walsh. Charlotte is a legal academic at Leicester Law School, University of Leicester, where she runs a course on criminology with particular focus on drug policy. Her research specialty is on the interface between psychedelics and the law, viewed from a liberal, human rights-based perspective, and she has published widely on this subject in several journals. You probably have read some of her articles, and she's also a very regular speaker at conferences and festivals. She is also a member. We have the honor that she's also a member of our steering committee of the Ayahuasca Defense Fund. And Charlotte, she's also involved in legal defense work and advocacy for policy reform. And I would like also to welcome Ben Meeus. Ben Meeus, it's a wonderful addition to this panel, and we are very honored to count on his presence. And Ben has a long experience in many issues related to ayahuasca. I would just mention a few of them. He holds a master's degree in international and European law and in Latin American studies, and has also been involved for 10 years in Santo Daime, and wrote his thesis about the legal issues related to the transnationalization of this religious practice. He also was intern at the UN High Commissioner's Office for Human Rights in the Indigenous People and Minorities Division, has been volunteer for a number of indigenous people's causes since then. This includes the construction of Indigenous Center for Health, Education, and Spirituality, presided by Benki Piyako, which is a Nashaninka leader that you all probably know as well. Okay, well, welcome. And I would like to pose you a first question to start the debate, and I would like you to explain to the audience how does your work relate to cultural or religious use of psychoactive plants materials that people have been prosecuted for using, and how do you see this situation in the context of international human rights? So, Jeffrey, perhaps you want to start.
Well, it began with a very personal challenge. I've been working with indigenous communities for 35 years. With the use of sacred plants within ceremonial context. And my first introduction to the use of ayahuasca was in 1990, so 29 years ago. And at that time, I was working to help establish a context for the religious use of sacred plants in the United States among traditional societies. At that time, the United States Supreme Court made a decision that said that the Constitution that protected the free exercise of religion in the United States did not protect the use of sacred plants in religious ceremonies, specifically peyote in the Native American Church. And I was involved with a movement to help to restore those rights, which led to the passage of a law in the United States called the Religious Freedom Restoration Act, which restored the rights of minority religions or religions that were often misunderstood. And as that work continued, I became introduced to the use of ayahuasca within the Uñado Vegetal, which is the religion that I still follow today. And then there came a point where the authorities in the United States challenged our legal right to our religious practice, and we had to end up suing the government of the United States, taking them to court on the basis of human rights, on the basis of our religious freedom, and on the basis of a number of different arguments that we made. It was a process that lasted over 11 years that resulted in the Supreme Court of the United States unanimously affirming our legal right, and then setting up a precedent for the responsible sacramental use of the ayahuasca tea in the United States. That is a model that's now been implemented in Canada, and we're looking to help other countries find a way to regulate, to allow for the beneficent practices of people who are using these traditional sacred plants that were provided to us by the Creator, provided to us by nature in order to help better our lives and better ourselves. And so this has been a work that I've been actively involved in for 35 years. I was invited to speak at the first international conference in ayahuasca that was held in Ibiza in 2014. And at that time, I was very moved by the work that ICEERS was doing, and I offered myself to come to be an ally and a friend. And today I work with the steering committee of the Ayahuasca Defense Fund. So this has defined my adult life for the last 35 years.
Thank you, Jeffrey. And I have to say, he works very hard with us, so thank you. And Ben, please, if you would like to continue.
Yes, for my part, my experience or my personal involvement in these questions started when I was 16. I have to say ayahuasca personally helped me with quite some issues on depression and addiction, common issues with youngsters these times. And that obviously put quite some pressure, in a sense, on my shoulders, because I saw that people were very worried of giving ayahuasca within a religious context to a minor in Belgium. Later we noticed that, of course, there were quite some issues on a legal point of view. So I decided to start studying law in really having that thought already that one day this will probably become problematic or encounter certain issues. And it did. In Belgium, for example, there's been various actions, be it by the public ministry, by the federal police's division of harmful sectarian organizations, which is placed in the anti-terrorism brigade, and then judges that have released quite some prejudiced statements in deciding on the future of Santo Daime or the religious use of ayahuasca within the country, leading to the expansion of Santo Daime, well, the moving of Santo Daime churches to the Netherlands as well, where in the Netherlands 2 churches of the ICFLU branch were particularly recognized at that point already. In 2001 they had obtained recognition, but then the other churches moving due to, well, basic necessities of continuing their practice were not recognized, were working in some kind of gray area. So I decided to also there, as I developed my law studies already and I had finished my degree in other questions of human rights related to minorities and indigenous peoples, but then in Amsterdam I decided to study Latin American studies further and write a thesis on the expansion of the use of ayahuasca and the legal issues, encountering the same kind of paradigms of prejudice and difficulties on legal issues. Where I started noticing the kind of need for some kind of internal housekeeping, let's say, of the communities and the groups and the peoples that wish to engage with ayahuasca in legal systems that might still require some further development of their rights. And so I became board member and started developing together with some very qualified people in the Netherlands in CLAREA, which is the Center for the Legal Assessment of the Religious and Ethical Integration of Ayahuasca. We proposed that to the public ministry and the judges of Amsterdam as a self-regulatory body, which could enter into dialogue with communities, with public ministry with regards to bookkeeping, transport, fiscal transparency, all issues ethically related to the use of ayahuasca within these contexts. And we have been basically offering and been slapped the hand saying this was not something to be used. At that time, I was accepted for an internship at the United Nations Human Rights Office of the High Commissioner, and I continued working in the participation and the development of the rights of indigenous peoples in that division there. In seeing the need also to start including the voice of indigenous peoples within this expansion, and I guess many people have seen that need, so it's been a great honor since then to be able to get to know the indigenous side of the story. I cannot speak for them, but I can only say it's been for me, myself, also very eye-opening, even though I've been practicing with ayahuasca for quite some time at that already. And then, well, just to conclude, I have had also the pleasure to be able to help, to be present in the Indigenous Ayahuasca Conference as well, and then to help construct a Center for Health, Education, and Spirituality, conform the traditional medicinal practices of the Ashaninka, and see how we could further help the indigenous peoples create their own rights within our system, and have their views respected and understood. So,
Thank you, Ben. Charlotte, please.
Hi there. So as Constanza said, I'm an academic lawyer, and I've been focusing for a number of years on looking at how the prohibitive drug laws breach human rights. And I think there's a lot of people who are looking at drug policy, but there's not that many people in drug policy who are looking at the plant medicines. And there's quite a lot of people looking at human rights, but again, not a lot of people who are looking at human rights and how they might be impacted by prohibitive laws in relation to the plant medicines. So once I sort of started looking at this area, I thought there was this kind of real sort of niche area that had been neglected to a certain extent. And also it was really transparent that the drug laws do breach human rights in multiple ways. And you're sort of asking about how our work relates to religious freedom. And my work does very much relate to religious freedom, but I also think it's important to kind of sort of say at the outset that it's almost an artifact of how the human rights are set up, that we divide it up into, you know, like religious freedom, right to freedom of thought, right to autonomy, right to self-creation, because it's all totally inseparable. You know, if for instance you are drinking ayahuasca for spiritual reasons, that connection with spirit is going to affect how you are feeling in terms of your mental health, in terms of how balanced you are. And then obviously how you're feeling in your mind, that just has these cascade effects on your body, on your immune system, on everything that's going on in your body. So, and then also, you know, your right to express yourself, your right to become the best version of yourself. All of these things are inextricably entwined. They're not these kind of artificial rights, but we're sort of forced, in a sense, in the courts, like we have to follow the structures that have been put in place and sort of think about how we might challenge the laws by divvying it up into these different rights. But I guess that's something I would like to stress, is that it's a false division, and everything is sort of interconnected in that sense. But anyway, I sort of started writing on this area, and then when I was first doing it, it was largely abstract in the sense that I was just writing articles and giving talks. And then what started to happen was that people who were being prosecuted for plant medicines would contact me and talk to me about their cases and ask for help. And then I was sort of working loosely and with some other people where we would work together and try and come up with defense strategies and ways in which we could sort of weave our way through the loopholes of the law and hopefully get some of these prosecutions thrown out of court. But it was in a really kind of sort of unstructured way, in a sense. It was just relying on the fact that people had heard of us and would contact us. And then in 2014, I was asked to come and speak along with Jeffrey. It was where I met the whole ICERS team. And that was just it was an amazing happening, because it was like everything I'd always wanted, was where this was much more coordinated. And there was a much less of a chance that cases were going to come to court that would set bad precedents because of all of the support that ICERS offer, you know, so that in terms of that, if there is somebody who's being prosecuted, then you're going to give them, you know, good expert advice, put them in touch with good legal defense people and so on and so forth. And so that was a real sort of sea change for me in that sense, was to be connected with you. And then since then, I've sort of carried on being involved. I'm involved in the Ayahuasca Defense Fund. And then we also had a sort of like a little bit of an offshoot where, as a result of that work, we were involved with practitioner groups to a certain extent in the UK, thinking, rather than just being reactive and thinking about how we can challenge the laws, thinking more about like ways forward and what would the future look like our ideal vision of the future, and to try and kind of, you know, move towards that. So I guess it's sort of looking at the problems with the laws that we do have, but also thinking about ways forward, but always coming at it from this human rights informed perspective, and also an evidence informed perspective as far as is possible, I think. So.
Thank you, Charles. Thank you, all of you, for this very useful introduction to your work and your lives. And we would like to play the video now. The video that Ahmed Saheed, the UN Special Rapporteur for the freedom of religion of belief, sent to us. So he sent a message to the audience of the conference, and also a brief explanation of the most important issues connecting freedom of religion or belief, human rights, indigenous rights, and ayahuasca-related issues that we are discussing during this conference. So, thank you.
Good afternoon, and greetings to all at the World Ayahuasca Conference 2019. My apologies for not being able to be with you in person today. My name is Ahmed Saheed. I am the United Nations Special Rapporteur on freedom of religion or belief. My duties are to examine the challenges that are faced by all persons in the exercise of their human right to freedom of religion or belief, and to advise governments on how to address all forms of intolerance and of discrimination based on religion or belief. My work also requires clarifying the normative contours of this right. The right to freedom of religion or belief contains two broad aspects: an internal forum of thought and belief, which is an absolute right which cannot be interfered with in any way, and an external dimension of manifestation of that religion or belief, which in some limited circumstances can be restricted. The right to freedom of religion or belief also includes a right to equality and non-discrimination, covering both direct and indirect discrimination. As all human rights are universal, indivisible, interrelated, and interdependent, there are a number of complexities that need to be disentangled in delineating the scope of the right to freedom of religion or belief. Some of the overlaps, such as the right to culture, right to freedom of religion or belief, the rights of indigenous peoples, and the right to health, reinforce each other in many ways, while some intersections amongst different rights can create tensions that need to be resolved. Therefore, addressing the overlaps and intersections among various rights, including ensuring that all rights are respected in a holistic manner, means that the scope that states have to limit this right requires close examination. Let me speak directly to the issue before the panel. How can the right to freedom of religion or belief of indigenous peoples be guaranteed when the exercise of this right requires using psychoactive substances that tend to be controlled at the national or international level? The answer that my mandate can provide rests on an appeal to the proper application of the limitations regime provided under international human rights law. This regime requires that the right to practice one's religion or belief can be limited only on the grounds of protecting public safety, public order, public health, public morals, and the fundamental rights and freedoms of others. However, it is not enough for a state to invoke one or more of these grounds. It must demonstrate with evidence that it also strictly meets other criteria. Thus, the state must ensure that the limitation is written down in a clear enough law, that the restriction is proportionate to the pressing social need that it seeks to address, The limitations be neither discriminatory nor destroy the right itself. Laws of general effect may appear to treat everyone equally. However, they may affect different communities differently, creating indirect discrimination. In these cases, exemptions or reasonable accommodations need to be made to ensure that there are no hidden forms of discrimination. The question, therefore, is, can states prohibit the use of drugs that are part of religious ceremonies? The state practice varies, with most states banning the use of drugs that are proscribed on international conventions, citing compelling public interest related mostly to public health. A limited number of states provide specific exemptions or explore flexibilities in international drugs regimes to distinguish between general and sacramental or spiritual use of such drugs. In these countries, there is case law and legislation that can be used to provide the space for the sacramental or spiritual use of drugs. In such countries, there is generally a robust commitment to freedom of religion or belief. Beyond these states, one could cite the recently adopted international guidelines on human rights and drug policy. In outlining the obligations arising from human rights in regard to drug policy, the guidelines very clearly summarizes the position under the right to freedom of religion or belief. It recommends two things. First, that states may utilize the available flexibilities in the UN Drug Control Conventions to decriminalize the possession, purchase, or cultivation of controlled substances for personal consumption. And second, that states consider exemptions within drug legislation allowing the cultivation and use of controlled substances for religious purposes, including in rituals and ceremonies. These recommendations are clearly to be applauded as they reflect a progressive stance with regard to the human rights of indigenous groups. However, it would require a lot of awareness raising and advocacy to ensure that these recommendations are adopted widely and that indigenous peoples are guaranteed their right to freedom of religion or belief on equal terms with all others. I welcome engagement with my mandate from those in this space as I consider how I might be able to advance the normative shifts necessary to support communities in their quest for a more humane and human rights-centered approach to drugs, including the cultivation of sacred plants. In conclusion, I commend the organizers for convening an inclusive gathering and highlighting the importance of letting communities have the space to develop their own strategies and advocating for their solutions. I wish to express solidarity with the indigenous communities in their quest to ensure the full enjoyment of their right to freedom of religion or belief under the international human rights law framework. I thank you and wish you all the best.
Well, we are really honored that the UN Special Rapporteur on Freedom of Religion and Belief sent this message and this fantastic explanation on the main issues interrelating freedom of religions, indigenous rights, and human rights. And I would like now to ask my colleagues at the table if they would like to comment on some aspect of Ahmed Saheed's intervention video.
So I'd like to, as initially, just kind of give a little bit of background about the whole notion of human rights and international law as it relates to human rights as well as drug policy, because this idea of international agreements around human rights really became the necessity for it became evident after the Second World War, where after the use of the atomic weapons and with the extermination of peoples on the basis of their race, some aspects of the human condition were also revealed, that there was a sense that the communities needed to speak to one another. And so the United Nations, among the necessities, came out of this time, as well as in 1948, the Universal Declaration of Human Rights, which defines rights that are recognized as being universal, that are inalienable, and that are part of what we as human beings living on this earth have a right to be able to count on from governments. And so within these, there were treaties that were negotiated that defined some of these rights, and some treaties are still being defined. There was a treaty that was recently developed related to culture that was just a few years old. And then there was a treaty developed related to indigenous rights that's celebrating its 11th year in existence. But the three treaties that relate to the issues that many of us have faced relate to international drug policy, which was within the awareness that there was interrelationships between all the countries and the communities of the world. There came to be developed a politic around drug laws. And the first treaty in this respect was established in 1961, and it was focused on three plants: the cannabis plant, the poppy straw, the poppy plant from which opium and other painkillers are derived, as well as the coca plant. And this treaty only had to do with narcotic substances that could be derived from those plants, and was very specific in terms of its treatment of plants. 10 years later, there was another treaty that was developed, which was the International Convention on Psychotropic Substances, which listed different substances that had been developed or that could be extracted from natural products that were of concern to the international community. So this was early on in the stage of the movement where psychedelic compounds were stated to be widely distributed, LSD and other things which were of social and political concern at that time. And among the substances that were listed was the substance dimethyltryptamine, which can be found in preparations of ayahuasca and preparations that involve Psychotria viridis and other plants that contain that active alkaloid and compound. But very specifically, the treaty said that it was not controlling plants. It was only controlling the chemical compounds that could be found. And it even gave examples in the treaty of 3 different kinds of plants that had cultural and religious uses, where there was an active compound that was prescribed by the treaty that was not intended to be, that was meant to be tolerated, was the language that was used in the commentary to the convention. And the 3 plants that they listed were the psilocybin mushroom, which was used among the Maya Indians in Central America. There was the mescaline plant, which was used within peyote by also the Indians of Mexico and certain tribes in the United States, as well as and Canada. And also a plant that seemed obscure at the time that I had to do research about, which was a plant called Mimosa hostilis. And interestingly, and this came from the work of Richard Schultes that Wade Davis spoke about earlier in the conference, of all the thousands of plants that contain psychoactive properties, the conventions explicitly mentioned a plant from Brazil containing dimethyltryptamine that was used in rituals where the name of the tribe that used it was mentioned. So very interestingly, that even in 1971, where there was the necessity or the perceived need to develop a policy around the use of these psychoactive molecules or chemicals, there was a recognition of the use of plants within religious ceremonies that was not intended to be restricted. It was intended to be tolerated. So these, the outline that Ahmed gave in his very precise and articulate speech is something that we could study. This document that was just produced in March that relates to human rights and drug policy, because in the application of drug policy, and the ayahuasca community has seen this, where in certain states have taken a very repressive approach. There have been people in prison, there have been people who have been lost their property in relationship to their use, and the drug laws have been, in many cases, misapplied, misunderstood by the countries in the way that they're supposed to be applied. And so this initiative that was born of the United Nations Development Program, the World Health Organization, the AIDS Council within the United Nations, and this commission that was formed to examine these issues together, came up with a definition of what is correct and what is not correct in terms of public policy in relationship to the drug laws, how the drug laws need to be applied with respect for basic human rights, with respect for constitutional rights, with respect for culture, and as Ahmed said, and also respect for human health. One of the issues that we were talking about today in many indigenous communities, ayahuasca is the medicine that is the basis of healing different kinds of disease. It's the foundation of culture, it's the foundation of life. It's not something that you can say, well, your way of life has somehow become criminalized because people in countries who are concerned about chemical substances decided that your cultural use of plant materials that grow in your territory somehow is now a crime. And so it's an area of law that's evolving. Every case that we are successful in affirming this right as part of the beneficial treasure of humanity, that these plants were produced by nature for our use in order to help us improve the quality of our lives. And so I wanted to set the framework of why these treaties that relate to human rights and drug policy, cultural rights, indigenous rights, these are important. And this explanation of the conventions that this document explains affirms that there is a fundamental right to the freedom of religion, and the use of plants that contain psychotropic compounds is part of that right that needs to be respected by the nation states. And so that was my thoughts that I wanted to share about Ahmed's very concise words.
Thank you, Jeffrey. Also, for letting you know that the following panel we are having in this hall, one of the persons behind this document, the guidelines on drug policy and human rights, will be Julie Hanna will be participating. So it will be also an opportunity to know more about this document and how it came to be. I would like to ask now Ben or Charlotte if you would like to add to make a comment on Ahmed's. Thank you.
I was sort of struck when I was watching Ahmed's talk. He's laying out basically the way in which the human rights provisions should put a brake on drug prohibition and the things that shouldn't be included within it. And coming from the UK, we're sort of like a stellar example of getting it all wrong. We sort of do the opposite of what he said that we should do. And so I thought maybe I'd just kind of talk you through, like tell you the story of what we do in the UK to show you how wrong you can get this. And so ayahuasca isn't included in the international conventions. It isn't included in our domestic drug prohibitive legislation, but DMT is, and as you know, you all know that's the active constituent. And we also have a provision in our domestic drug legislation where if there's preparations containing a chemical, then they can also be illegal. So there was this sort of grey area as regards whether or not people thought that ayahuasca would fall under a preparation and therefore fall under the Act. I think very much it doesn't. You know, the international conventions have made clear that it doesn't. A preparation, to my mind, should include some kind of chemical change being instigated, which doesn't happen in ayahuasca. In mixing the brew. And so we were in a situation where it was really significant what would happen the first time that somebody was prosecuted for ayahuasca in the UK. And I think even the sort of the backstory to which case it was that ended up before the courts is really, really telling. So I think many of you were in here yesterday when Adrian Freeman was talking about his tribulations with the law and how he was arrested for having 80 plus litres of ayahuasca. And Adrian's part of, a very, very structured, very ethical Santo Daime church. And then he was sort of saying at the end of his talk how even though they had all this very powerful evidence against him, they dropped the case. And in many ways that sounds amazing. It's like, the plant's smiling on us and the case got dropped inexplicably. But there's actually a sort of, this is supposition because we don't know the machinations that go on behind closed doors. But I think there's a darker side to that, because what happened was that after Adrian was arrested, there was an individual who was working as a shaman in the UK who wasn't in this kind of like structured organization with a history, it was like they leapfrogged that case so that was the case that came before the courts. And so they dropped a case where there was somebody with 80 plus litres of ayahuasca, and they prosecuted a case where they were prosecuting it basically on the remnants, the residue of the ayahuasca that was in the drinking cup. And then they used that case as the case to decide whether or not ayahuasca was illegal in the UK. And so if I can, I'll just kind of talk you through what happened there. And so the argument, Aziz made kind of like two main arguments, and his first argument was that ayahuasca wasn't included within the law, and so therefore the prosecution should fail on that basis. And they didn't accept that. They just, and this is one of the things that happens in lots of courts, they just conflated ayahuasca with DMT. And I know you've written a really lovely paper, Constanza, where you talk about this whole sort of like metaphor of like the boiling down of this, just really complex culture into the brew, and then sort of boiling it down even further, so you're just dealing with the sort of the psychoactive molecule in the brew. And that's exactly what they did in the UK. I was present in throughout the court case, and so it was just like ayahuasca equals DMT, and so therefore it's covered by the law. And then the second argument was, okay, well, if you're going to say that, then we should have an exemption for religious freedom. And one of the things that I think is interesting, and Ahmed was talking about how he wanted to clarify the sort of the normative concepts of the right. And something that's always struck me when I'm looking at, so you've got the right to religious freedom, and then you've got the qualifiers. It's not absolute, my right to religious freedom, if it threatens public health, if it threatens, crime and disorder, then you can interfere with my right to religious freedom. But when you think about that right in relation to ayahuasca, I think it's really interesting. So we have an absolute right to freedom of religion. We can believe what we want, that is absolute. But it's the manifestation of that right that is qualified. And so the way that it's always framed is, we have this absolute right to our kind of ayahuasca-inspired belief system, but whether or not we can drink the ayahuasca is caught by the qualifiers. And I actually don't think that maps very well onto what's happening. The drinking of ayahuasca is not a manifestation of your belief. It's the whole substrate of the belief. You know what I mean? These aren't two separate things. So I think there's even kind of an argument that the qualifiers shouldn't apply. It's not just a manifestation of it. It's sort of like if you imagine stripping the ayahuasca out of an ayahuasca using church, what do you have left? You don't have nothing. Of course, you still have a powerful community, but it's so central. But I mean, I think that probably is never going to fly in the courts, but it's something that I've always sort of thought about when I think about this. But then, so if we say, well, drinking ayahuasca is a manifestation of your right to religious freedom, then what the courts are doing before they can say that you can't do that, they would have to show so it's really important, they're interfering with your right to religious freedom. They have to show, using evidence, that you drinking ayahuasca in the context in which you're drinking it, so that might be within a sort of structured framework of a church, would be a threat to public health. And this should involve like a balancing exercise where we bring in the experts and we look at all of the evidence, and the burden of proof is on them. We have a right to religious freedom, they're breaching it, so they need to prove that there's a reason why they're breaching it. What actually happened, what happened in the UK, and I've seen it happen in other cases since, is that they don't do that at all. They don't look at the evidence, they barely engage with the human rights-based issues. They're mentioned in passing in court, certainly in the UK, it barely got kind of a breath. And they came up with this really sort of circular logic where they said, if it's included within the drug laws, which arguably it isn't included within the drug laws, but they basically said if it's included within the drug laws, that means it's harmful, And so therefore the qualifiers apply. It's a threat in the way that the qualifiers suggest. That's absolute nonsense. The whole point of the human rights legislation and the obligation that is on the courts is that they are analysing the criminal laws that we have, and they're seeing whether or not they respect human rights. Not to just say, oh, well, you've made that illegal, and so therefore it's harmful. It's a total abrogation of duty. They're not doing what they're supposed to be doing. So they did that, which is really, really disappointing. And then the other thing that they did, which again was just nonsensical, was they said that we have a duty under international law. We have international obligations under the UN conventions that you've just been discussing. And so therefore we can't say that you can drink ayahuasca. Absolute nonsense. You know, ayahuasca isn't included in the international conventions. Even if it were, there's exemptions, you know, constitutional exemptions. So the fact that we're signed up to the European Convention on Human Rights in the UK, that could be used as an exemption. Our right to religious freedom should be protected. And also just even looking at, you know, this was after your success in the States. So we've kind of proven that you can have those exemptions without it being a problem for the overseeing body of the UN conventions. You know, that's been shown. So it's when you sort of look at what happens in the cases, it's just nonsensical. They're not doing what they're supposed to be doing. Their logic doesn't bear up to any kind of scrutiny. And so, you know, I think you could. I think you could take the view that what's going on here is really the qualifiers are engaged so easily that the right becomes meaningless. You know, we have this thing in the UK and indeed throughout Europe where we have a really sort of liberal approach to what constitutes a religion. So what's covered by the right to religious freedom? It covers atheism. You know, it covers any kind of belief system. It doesn't have to be some sort of structured religion. It's just, you know, spirituality. It's your belief. It's very different from the US where there's kind of, you know, parameters that you have to satisfy. We don't have that. So it seems like we're really, really liberal, but then we let the qualifiers kick in with such ridiculous ease that in fact the right becomes totally meaningless in these circumstances where people are using sacraments. And I think one of the things that's always really disappointing to me is, you know, that when you sort of unpick what happens in this case and indeed in many of these cases and not just in the UK, is that you can see that like you sort of have this sort of optimistic idea that people will apply the law as it's supposed to be applied, and they'll sort of work their way through it. And it's not what happens. It's a political decision. You know, it's all about power. And so I think that kind of seeing what Ahmed is saying just kind of makes me think more. It wouldn't even, for these instances of religious freedom, it doesn't even necessitate like wholesale end of prohibition, which I firmly am behind, but it doesn't even necessitate that. All you have to do is apply the provisions we already have properly, you know.
Thank you, Charlotte. Ben, would you like to comment on Ahmed's statement?
Maybe I can welcome the fifth panel member who's flying around here. And then,
I wish I was like Obama, you know, when he did that thing without even looking, where he just plucked it out of the air. But
no, I guess I can also give a quite an overview of the observations that I've been able to make as well in the legal cases of Belgium and the Netherlands. I think first of all, well, of course, when asserting the right to religious freedom, obviously, in a way, it makes sense, especially when you go and look at the history. If you go and look at the history in Europe of the aspects that could become problematic when you have an international expansion of a religious practice that uses psychoactive substance in their rituals, of course, you fall within a paradigm that has to do with, of course, the use of drugs, but also harmful sectarian organizations. We have quite a history of collective suicides, of manipulation psychologically, of obtaining the patrimony of people, of power struggles within, you know, sectarian types of activities. So there's a justified kind of difficulty of perception from the parts of people that, you know, have to decide on the fate of such a movement without being informed. Having said that, there are obviously clear injustices related to the expansion of the use of ayahuasca in Belgium and the Netherlands. I can just cite a few of the examples. For example, in Belgium, as I already mentioned, we had the anti-terrorism brigade of the federal police, and they have a special unit for harmful sectarian organizations. They're well organized. They have an advisory center, etc. So I went there, and I also asked audiences with the chief of this section, and I never really got to talk with him, but I did send him my thesis. And they basically, before any before any legal precedent was set in Belgium, they already invited the leaders of a Santo Daime church, which we call padrinhos and madrinha, and they invited them to a private audience, saying that, well, of course, with the same story as in many cases, DMT is prohibited, therefore ayahuasca is prohibited, and you simply cannot practice your religion here in Belgium. Then they conducted a house search, which, in a way, I kind of like to relate that story, because the padrino of this church told me that he felt like this was in old times when they went and burned the Bible in certain houses. There's a sacrament, a holy book that in this case is in the form of a liquid, but is basically being taken away from your home without any reasonable justification or any dialogue or any open discussion for pluralism and inclusion. So after that, it was interesting. I wasn't aware of the cases in Belgium, but then I read I didn't follow them up quite well, but then I read an article where the public ministry noted that, well, after the prohibition of Santo Daime, we had to do it. What if someday a religion comes and wants to use heroin in their activities? So there's this clear misunderstanding of really what ayahuasca is, and this unwillingness to really engage further. And that became very clear also in the readings of the cases, where the judge basically starts with a first, I wouldn't even call it assessment, it's really a statement that had no scientific foundation whatsoever. They just said, ayahuasca, the users of this tea hallucinate, quote. So that obviously puts you in a very difficult position to begin with and assert your rights as a religious minority. Just another example, in the case itself, they assert that ayahuasca would be toxic for the brain, and they make reference to a report from the Royal Academy of Medical Science of Belgium that referred to another report from France from the 90s, where they basically pushed down on a daily basis a lot of harmaline in rats, making it have a toxic effect on the brain, but it obviously is so dislocated from the actual reality of what ayahuasca use is for religious practitioners. So, and then at the end of we had the first instance, second instance, and then cassation, and apparently the second instance judge told one of the Santo Daime leaders there at the end, on an informal matter, like, you can, it's okay, you can go practice yoga, which is, in human rights terms, let's say, an incomparable alternative to the practice that he's practicing. So, going to the Netherlands, same kind of story. DMT started in 2001. There's been around 5 or 6 cases where the main argument of the public ministry was always the same. DMT is prohibited, so ayahuasca is prohibited, and basically no further real assessment. But in 2001, actually, the first case, they were lucky to have a judge. I wouldn't call it lucky, I would call it common sense, but they had a common sense judge who really made the assessment and decided to give freedom of religion to 2 particular churches who were involved in the case, making this circumstance, as I explained, where others that had to move to the Netherlands were basically stuck in some kind of gray zone. I'm not going to comment very much further on that. I can only say that now even the Santo Daime community as well, in 2017, after almost 17 years, 16, 17 years of legal battle. Now in 2018, they are again standing in front of a judgment that could really turn their fates upside down, and make Santo Daime, prohibit Santo Daime in the Netherlands, with, of course, profound consequences as a precedent, as an important precedent for the international community. Again, now at the final stage, they recognize that for Santo Daime, ayahuasca is essential. They had recognized that, but they had recognized that its use in itself might not necessarily be a public health issue, but they considered that the way it's being used, and considering the amount of people attending, and considering, the side questions, that it would still be a public health concern. And now we're in the process of going to cassation, and which, depending on the consequence, might lead to the European Court of Human Rights. I hope I made that more or less clear. But what is clear from our part is that, or from an academic point of view, is that the public ministry is really down to prohibit any practice with ayahuasca. Having said that, and besides the clear injustices, I am always very fond of reminding the fact that rights do come with certain responsibilities. I have been able to make some observations through field research in Brazil as well, and through really studying and going towards the churches, the importance of ethics, and despite the injustices and despite the fragmentation of international law that doesn't recognize the holistic nature of certain rights, it's the use of ayahuasca in itself, according to my observations, does involve certain ethics. And a 25-year-long process in Brazil has already recognized 2 of those, which I find particularly important to restate, so that there is always a profound, let's say, reflection exactly on what religious communities and indigenous peoples are doing while asserting their rights, and these are very common, and I'm sure everyone has a knowledge about them, is the non-commercialization and the use of ayahuasca with other substances that might not be possible to really assert your rights within legal frameworks, and from a public health point of view as well. It's a matter of responsibility to me. The responsibility, the word in itself, of course, contains the ability to respond. And when you have people that are engaging in certain activities and you ask them, will you stand in front of justice and explain that you are asking this kinds of money, or you're not able to grant certain transparencies there and there, or you are using a certain kind of substance that cannot be proven to be healthy in combined use with ayahuasca. These are very ethical questions, and they cannot be discarded. I repeat, they cannot be discarded by any of the religious communities, by any of the indigenous peoples, by anyone wanting to engage in the ritual use of ayahuasca. I just wanted to restate that, and perhaps we can discuss further.
Thank you, Ben. I think it's our moment to move to more national specificities, and also, I think it's our moment to move forward to envision the future. And I would like to know some insights on how do you see the future of ayahuasca practices, and how the authorities, the legal and political authorities, will should be dealing with the globalization of ayahuasca. Perhaps we could start by asking Jeffrey about the recent developments in Canada, because following the decision of the Supreme Court of the United States, the next country to allow for licensing of the religious or sacramental use of ayahuasca was Canada. Jeffrey, you were involved in this process as well, and I'd like to ask you if you could provide a brief explanation of how that accommodation with the Canadian authorities.
Yeah, I think each country's constitutional framework, each country's has certain values that need to be respected. So when you approach the authorities in a given country, you need to understand what are the essential elements of the culture that are present within the culture in Belgium, the culture in Switzerland, the culture in France. And in each country where we seek recognition for our practices, we have to understand the nature of the cultural foundation as we approach asking for accommodation. In Canada, it was very similar to the United States. There's a strong commitment to human rights. There's a strong commitment to the support for the First Peoples. They call it the original inhabitants, the indigenous cultures. And there was a movement towards more liberal drug policy with respect to different substances. So we arranged, rather than going through the process of suing the government, which took a long time and cost a lot of money, we engaged in conversation with people from the health ministry, from the justice ministry, from the different departments, the public safety ministry, and we got support institutionally from all these different departments, so that when we came to make our request of the Office of Controlled Substances there, the work had largely been negotiated, and they were able to use the system of licensing that had been extended and that we had achieved in the United States. They adapted it for a uniquely Canadian way of working and tried it as an experiment, for 1 year. And that experiment will be concluding this month, and then we'll be entering into the second phase of that. And we've asked for an accommodation for 10 years rather than a year-by-year approval, because unlike a commercial enterprise that's, dispensing a substance that, could have health risks and they're looking to see what the results are after a year, this is the foundation of our religious faith. It's not something that should be tied to the political changes of the country and who happens to be in office and how they feel about it. We've established through years of work that it was a fundamental right, and we achieved a certain respect. So one interesting element of this that I think is worth repeating here, in the negotiations we had with the Canadian government, we explained that there was a problem that they had with the model of prohibition and the model of the alternative, which most people propose, is legalization. And in our view, in terms of this very powerful transformative tea, neither one of those approaches are really viable. The prohibition in and of itself leads to people who are sincere religious people or spiritual practitioners being treated as criminals, and the complete legalization could lead to other corrupting elements coming in terms of unqualified people leading ceremonies, where harms could come. In any form of medical or psychological practice, there's a form of licensing where you prove, your ability to conduct, medicine or to conduct, therapy. And so we suggested that it would be of the government's interest, because there were actually 2 incidents of deaths that happened involving Canadians, and we went to the government and was able to explain these are in fact a consequence of not having a system of where responsible practitioners are accredited and then given license to practice. And they accepted that argument, and so it was coming from the human rights, religious freedom perspective that door was opened in Canada. And I think as we look at country by country, we have to tailor something that is that meets the understanding, of the cultural principles that are foundation of that culture. One interesting thing that I also wanted to mention in terms of what Ben said about the Netherlands, the most recent court opinion that came up in the Netherlands, and the first cases were very tolerant, of the religious use of daimi, of ayahuasca in Holland. But the most recent cases noted that there was Holland was being used as a center for importation of ayahuasca for the whole European continent. And there was a concern in terms of public order and safety that the tea that came in through the open door in Holland could be used in other countries and cause harms, and then what would be the legal liability of Holland for allowing it. And so these are other issues that have come to light recently in terms of the globalization and how different countries are responding to that with their own unique approaches. But I think it's the lesson is that you have to find what is the cultural key. There are places, for example, where the right to health and the right to traditional medicine could be another way of introducing the idea of a context for using ayahuasca. And here in Catalonia, there was an example of working with the local authorities here in Catalonia. The idea, as Ahmed said, the idea of a personal use is something that's recognized in many countries, in Portugal and many other countries. But the idea of collective personal use, where a group of people come together within their individual right towards their own health, towards their own spiritual practice, and share in a collective, is actually another alternative that's being developed here. ICEERS has been working with the local government as another approach to helping people who don't understand this phenomena to understand. And then the other thing that I think is really important is to show the social benefit, for people to be involved in activities in the community, to help the larger society, to be working, with helping people in different areas. The UDV has been involved with offering medical care to poor communities, to rainforest preservation, to the support of indigenous communities, to teaching illiteracy. So these ways of showing that there's a benefit to the world to allowing these practices, I think is important for our future as well.
Thank you. And Jeffrey, I would like to ask you as well, do you envision any change? Oh, okay. So, do you envision any change in the near future in other countries with respect to the recognition of religious freedom?
I'm very hopeful, and I think part of it is my religious faith, that the world was created for this. It was created for our awakening. It was created for our understanding of the nature of God and the nature of divinity and the nature of the human experience as something sacred. And so since this was the reason why the earth was created in time, more and more humanity will understand the need for this. And then also as more and more of us become involved with having transformed lives and bringing greater goodness into the communities, the more communities will recognize the value of supporting these kind of practices as well.
Thank you. And Charlotte, I would like you to comment on the recent punitive turn in Europe, and how do you see this evolution and how it may condition the future of this practice, or how do you envision the future of these practices considering this punitive turn?
I mean, I think you kind of talking about what was happening in Holland, and I think it's sort of sad what's happened there, in that when we were talking about what should happen in the courts was what had previously happened in the courts in the kind of earlier case, where they do this sort of evidence-based balancing exercise when deciding whether or not to apply the qualifiers, and then in the recent Dutch case, it was almost like a replication of what had happened in England. We had the same kind of circular logic, the same kind of reliance on international laws that actually don't apply. And I think, when I read the judgment, there was a lot of the concern seemed to be that maybe the terrain had shifted, in as much as that ayahuasca had gained a certain sort of prominence, like people that had heard of it, and there'd been sort of, some lurid media reports about it. It was a very different sort of landscape, I think, than when the original decision was made. And I think that maybe influenced the way in which that decision was made. And so there was a lot of talk, as you say, there was the fear of the cult, and they sort of expressed that in the judgment. And I think I think that, that sort of idea of what's a religion, what's a cult, to some it depends on sort of what perspective you're standing, whether you're inside or outside, and practices that are alien to you can kind of seem really strange, and then also they were using the floodgates argument, which in the earlier decision, they'd sort of categorically said it's not something that's going to spill out, whereas here they were saying that, that there's the sort of chance that people are going to be drinking ayahuasca, not for spiritual reasons, but sort of recreationally, and this whole floodgates argument. And I mean that, I teach first-year law students, and one of the first things that we teach them is never to use the floodgates argument. It's like the weakest argument you can possibly come up with. Like, the whole process of lawmaking is you draw lines between what's allowed and what's not allowed. And obviously, any line that you can draw, someone can say, oh, well, someone on the other side of the line might argue that that's what the law is. It's a process of drawing lines. You can always make that argument. It's really, really, we mark them down if they say that in papers, and you've got the judiciary using that as kind of one of their main reasons. So I think it's really disappointing, and I think there'd been a European court case that I think was also highly influential in the Dutch decision, where you see the same kind of thing. It's like everybody's moving towards those sort of weak judgments rather than balanced judgments. So that's not very optimistic, but hopefully, hopefully that will change. Did you ask me to say sort of more broadly about the future, or just the future in light of? I guess, like, when you're thinking about what you want the future to look like, it comes down in a sense to what your sort of underpinning philosophy is, like where you're coming from. And so I think I sort of come from the perspective where I disagree with prohibition in toto. I think that the state has overstepped its mark. I don't think that private behaviours of what we ingest should be anything to do with the state. I think it breaches all kinds of rights, the right to cognitive liberty, the right to autonomy, the right to self-creation, the right to freedom of religion. And so I sort of would come from the premise that rather than it being seen as, I don't think prohibition was never some sort of misguided attempt to protect us from harm that just hasn't played out well. It's drenched in racism and power games from the off. And so I think don't buy into the central premise that this is about trying to protect us from harm. It never was, and it isn't. And so I think start from that premise, and then you want to kind of raise the whole system to the ground and start afresh, rather than it's almost like a favor that you're not prohibiting certain substances. And so I kind of come at it from that perspective. I totally agree with you, Jeffrey, in terms of once you start moving towards, if you're talking about personal use, then I can do what I want to myself. Once you start talking about where you're sharing and there's some kind of like collective shared use, of course there has to be some kind of regulations coming in. But then I think the interesting question is, where are those regulations coming from? And you were sort of mentioning this as well, but maybe to build on that a little bit, I think really important that those regulations are not coming from above, but that they're coming from below. The last thing that you want is a situation where those are being sort of imposed rather than rather than kind of this process of the people who know what it is that they're talking about coming up with regulations. But I also do think it's really important that I think it's important that however it comes about, that the system of regulation doesn't just become a sort of attenuated system of prohibition. There are criminal laws in place. If people sexually assault someone in Circle, for example, or whatever it may be, we already have criminal laws for that. And so I think that's really important to remember as well. And so you might have guidelines, but I would never want those guidelines to mean that if somebody chose to go and do something on their own, I'm just going to go and trip in the woods on my own, or even like, with a circle of friends, that you would somehow be criminally liable. So I think it's great that we have regulations and a sort of a system in place, but it shouldn't be backed up with prohibition unless what's happening is criminal offences of another stripe. I don't know if you wanted me to say anything else, but the other thing I'm kind of like a little bit concerned about is that first of all, that we don't just go from this sort of system of criminalisation to one of strict regulation that basically means that loads of people would be sort of frozen out of the game. You know, people who are like fantastic healers who are working in the underground at the moment, if the system of regulation is really, really strict, then they could end up not being able to abide by regulation. And my other concern is also about this all being sort of subsumed by the medical model. You know, I think I do think there is a place for the medicalization of psychedelics, and I thoroughly applaud a lot of the work that is going on in that region, but it's not the only way. It can't be the only way. You know, for some people, that might be appropriate to take MDMA in clinical setting. For a lot of people, you need either that sense of community, that church space, or the magic of ceremony, and the idea that we can just kind of strip all that away and still maintain the magic. I think it's just not going to happen. You know, we can't. You can't strip out the sort of the natural element and the supernatural element and still expect this to work in the way that it works. And the reason that so many people are turning to these substances and these kind of methodologies is because what we have doesn't work. You know, like we have a crisis of mental health. You know, we have like division, ecological catastrophe, and so we shouldn't just be trying to kind of slot ourselves into existing paradigms because they're failing. I'm also concerned about sort of commercialization. You know, we see that already, that commercial elements kind of like jump in as soon as there's that opportunity. And I think, you know, like really sort of respecting the true power of these substances to kind of like upturn what's going on rather than just sort of like, let's just take the edges off late stage capitalism, you know?
Yeah, and that reminds me a statement I heard this morning in the indigenous space, that what really worries indigenous communities is not prohibition, it's commercialization and cultural appropriation.
Yeah.
So it's that we are dealing with different elements here that we need to probably overcome to promote this idea of human rights-based policy options. Yeah, for sure. Ben, would you like to add something on the future we are envisioning?
Definitely. Just briefly commenting exactly on what you said as well with regards to applicable criminal law already in place when certain misconducts happen. That's exactly some of the conclusions I made in my thesis as well, is to saying that basically every Santo Daime church could become a harmful sectarian organization, but that does not mean that Santo Daime itself is just as, you know, you can transpose that kind of thinking to any kind of religion. The surprising part, though, in the Netherlands was that even though we had this bottom-up self-regulatory efforts that have been made over the past 16, 17 years, we've sent 4 letters of cooperation and dialogue to the public ministry, and they never got responded by them, and so that was neglected. Also, so that was the surprising element as well, is just the fact that it was not recognized. And then with regards to the European Court of Human Rights, yes, the court case is problematic, but perhaps not that problematic in the sense that it was considered not admissible, meaning that a full examination of the case was not made. And I think the blatant injustice that's happening now might serve as a good precedent and does give me hope towards the future at the European Court. Well, if it ever gets there, hopefully not. But something I would really like to emphasize, and we've briefly touched upon it now, is the self-regulation bottom-up as well for the indigenous peoples. I think one of the voices that need to be heard in future discussions and that actually bring more understanding for us as well on the nature of what ayahuasca really is and all the dimensions this could have as a benefit for society and global environment, cultural exchanges, anything you can imagine related to this expansion is really, there is this necessity to hear their voice and to help them understand the situations that they are in, build their capacity, and that's exactly, I did have some experience therein, so I can only talk from my example, is that I've been to various international conferences with Benki Piako, who also presides the center that I've been working on, with him at the UN Expert Forum on Expert Mechanism on the Rights of Indigenous Peoples, the Permanent Forum on Indigenous Issues, and really trying to assert and make people aware on the international level on this necessity to hear them and address this fragmented nature of international law, because when you talk about environment or the preservation of cultural patrimony or intellectual property or human rights or religious freedom, we all find ourselves always working in a different with a different institution, in a different legal framework, and this is very difficult for them, and it's just not in line with their reality. So that's something we need to hear and learn from. At the same time, they're also uniting. I can only, again, speak from the examples I've seen, but in Acre, Brazil, I've been attending the Indigenous Ayahuasca Conference with around 11 to 15 different people actually discussing all these issues and creating their own views and filling in the contours of the rights that they want to develop. And that's something that we need to recognize, we need to hear, we need to support, and we need to engage to our fullest, the maximum of our abilities to try and understand and create frameworks that can accompany their desires as well, to engage with us and have also the rights to international travel with their medicine and be able to construct centers, etc. So that's what we've been trying to understand as well, based on the United Nations Declaration on the Rights of Indigenous Peoples, give some kind of foundation to the Indigenous Center for Health, Education and Spirituality presided by Benki Piako, is to have a basis on which to develop that, also engage in of course, reforestation efforts and cleaning the rivers at the same time with the income. So it's something very broad that does not fit in just a religious freedom exemption or just any type of insight we can have on that. So I just wanted to, perhaps further explain that in that light, it offers a basis for further cooperation with multidisciplinary groups, institutions, like recent partnerships that we are trying to establish with the World Health Organization, that would come with the regional offices of Peru and Brazil in a certain inception mission to start look what are the needs of Amazonian indigenous peoples, to really document, recognize within the framework of the WHO their traditional medicinal practices and their holistic nature, which is not just related to ayahuasca, but they have a knowledge of a variety of plants just continue working on that and strengthening their own internal good practices as well as a means for us to learn and have further engagement with them. I think that's so important, because they can really open our eyes to certain things that are so evident and might facilitate as well the changes of the paradigms that we find ourselves in when discussing legal frameworks. So I think that's a hope I have, and I really see a bright future in that, and the indigenous peoples are more than engaged in these issues as well. So I can only recommend that.
Thank you, Ben. I would like now to open the microphone to the audience. I don't see you, but I hope you are still there. Yeah, okay. Okay, I don't know. Okay, we have time perhaps for 2 questions, quick questions. Is there anyone? Yeah. Ben, Christy.
Thank you all. I wanted to ask, I think the whole panel, what do you think the opportunities presented by your recent attendance at the Parliament of World Religions might present for a strategy for normalizing these practices? and maybe explain, I think some of you were actually attending the Parliament. I'd like to hear some of your reflections on actually being there and what the first precedents were, but in the larger piece where that might present new avenues or adjacent avenues to what you've been discussing.
And the second question, please. Are you asking,
Oh, yeah.
would you like to ask something to the panel? Oh, okay, that's, yeah, let's go.
Quickly comment on it. I was indeed present at the Parliament of the World's Religions, so thank you for the question. I think the main objective of that was really to show and put the indigenous peoples on a level of equality with the other religion, the interfaith, the global interfaith community. So all religions recognizing that even though it's a very diversified field, indigenous spiritualities, even indigenous spirituality is related to ayahuasca, but that you should recognize that the spiritual nature of their practices is equal to the spirituality that any religious leader carries with them, and that's something. Of course, it's not a legal work. It's not it's rather diplomatic, let's say, but it's just common sense as well. And to have sometimes to have the interfaith global community giving some kind of recognition, which is of course the intent behind it as well, would help to further develop their rights as well and create further understanding. Yeah, I think that's the main idea as I understood it. So.
I think Benjamin Mudge is going to be presenting tomorrow, and he has a film that was taken, at the Parliament where different representatives of indigenous communities that use ayahuasca were presenting themselves, and it was very powerful. It was the first time they had ever seen anything like that, where indigenous people were there with their ceremonial dress, presenting their culture and presenting their presence in the community of human beings and religious tradition. And so I think it's, I think that the freedom that we all seek will happen when we're all free. And so I think when we advocate for the freedom of others, we're really doing what's best for ourselves as well. And so I think that this, movement in terms of working with the indigenous communities and their presence here at this Congress is really important. There's important, environmental considerations that I know have been, discussed here as well in terms of how important the Amazon region is to the health of the entire planet, and how these plants emerged within the Amazon region to bring our awareness to how these systems of life work and how these cultures that have existed, working with those principles for a while, it's really important. It's part of the treasure of humanity. So I think that this movement in the Parliament of World Religions is another area that we're looking to advance. I participated in the previous Congress that was in Toronto, so there's that was in Toronto, and so the Ottawa, and so no, Salt Lake City, and then the previous one was in Toronto. So I think it's another aspect of the globalization of bringing the people of the forest into the conversation as well.
Okay, thank you very much. I think we are run out of time. Charlotte, maybe you want to say some final statement? Okay. Okay, well, I would like to thank our wonderful panelists, and well, I hope you, well, let me just end by encouraging you to be creative in the defense of your human rights and the policy options you believe in, because as Charlotte was mentioning before, we tend to accuse the authorities of being too reductionist when it comes to ayahuasca, when it comes to traditional plants, traditional uses, but sometimes we advocating for policy change or legal change, we tend to be very reductionist, and we look at the reschedule of a molecule, we look at the change of a specific law, when we have a wide range of rights that interconnects with each other, and there are so many claims we can make to defend and to stand up for our rights, our freedom of religion, our cognitive liberty, the rights of indigenous people. and such along, etc., including our right to benefit from the progress of scientific research. So this is, well, I would like to finish here. Thank you all for being, for attending this panel. I hope you are enjoying the conference so far, and I invite you to stay for the next discussion, which will continue the topic of human rights and policy options. So thank you very much.